not accept what they had prior to 50, what the legislature, imperial legislature gave them or did not give them, or assume for a minute they had some trappings at the commencement of the constitution. Entry 63, list 1, 51, 65, and the actual practice in the institution. 2005 is perhaps the first tangible claim of status.
That point you have made. Thank you.
Then, my lords, one last thing and then I'm done. I'm obliged, my lords, for a patient hearing. Their submission on 30, please have a look at Dr. Dhawan's submission. Just have a minute, my lord.
What's the point that you're making?
The point I'm making is this. The submission appears to proceed on the basis that it is enough if it is shown that it's the minority community which is involved. The establishment and administration are the consequences of that status. Please have a look at that formulation, my lords. In my respectful submission, it amounts to begging the question. Please look at it, my lords. It's a little important because one of the key ingredients of their attack on Aziz Basha is on that. Please have a look at that, my lords. Page, give me the page. 2A. 2A, my lords, page 73. Page 73, 2A, my lords. 1A, yeah. 1A, I'm sorry. 1A. Please come to the conclusions. In fact, the body of the submissions also refers to that, but I thought for ease of reference, I'll come directly to this. 73, the conclusions. Aziz Basha, my lords got that, is internally contradictory in its reasoning on facts and law. 9.2. Aziz Basha failed to recognize that the word establish and administer are not preconditions to define a minority. I read their institution, it's not found there, my lords. Otherwise, it won't be complete. Preconditions to define a minority, but the consequential rights that flow from such recognition. The ingredients of the right that flow from 30 have been stated by TMA Pai at para 50 and other decisions. With respect, my lords, the position is the other way around. If you want to claim the benefits of a minority, you must show that you have established and you are...
No. There you're wrong. They're absolutely right that Article 30 says that all minorities,
yes,
religious or linguistic,
correct,
shall be entitled to establish and administer institutions of a choice.
That's right.
So it postulates that you are a minority and then gives you certain rights.
No, that's right.
Namely, the right to establish and administer. Therefore, their formulation that establishment and administration are concomitant rights once you are a minority is correct. It's on the basis of plain language of article.
No, I'm saying the submission appears to be that if you show that you are a minority, then establishing an administration is really something which comes thereafter. No, on the contrary, my lords, even if you are a minority and you have been involved with an institution, you have to show that you have established it and you have been administering it.
But that's exactly the point. That you cannot claim the benefit of Article 30 in respect of an institution if you have not established it and you are not administering it.
No, this is apart from, my lords,
it doesn't, whether you have established or administered an institution does not define as to whether you're a minority.
No, not in that sense. I quite see that, my lords, I quite see that.
So therefore, this is plainly a clear construction of Article 30 as it stands.
Very well, my lords. On that point, I have made some submissions. Please have a look at my written submissions on that, my lords. One last thing, my lords, and then I'm really done.
I've been mentioning
for all intents and purposes.
Last submission of Guru.
Please see the 2006 Central Act providing reservations for SCBCs and SCs and STs. That act provides that all central institutions shall provide reservation in terms of 15 and 16. And by definition, institutions of national importance are covered by it. So AMU will have to provide that reservation, but they have not been, because there is some provision in that act which says that if the parliament declares a particular institution to be a minority institution and certain other conditions, then yes, it need not provide the reservation provided under 15 and 16. Now, AMU has not been declared as such, but still, my lords, it's not being provided. Therefore, we are looking at what, my lords, as what Mr. Sibal said, is it merely that 50% which they claim for a particular community, or are we not looking at the larger umbrella of 15 and 16 across the spectrum? foreign institution declared to be of national importance with thousands of crores being pumped in to keep it and make it an institution of excellence. And throughout has not made any specific overt claims of minority status except that 2005 or the in between 1981 my lord's amendment, which in my respectful submission is subject to the vagaries of political changes.
All right. Thank you, Guru.
I'm deeply obliged, my lords. I overshot the time, but my apologies, my lords. I'm deeply obliged for a patient here.
Navre, what is the point you want to make?
Lord, I will not repeat anything that I promise. Lord, my written submissions are in volume 2A. Page 58, Lord, it starts, but actual submissions start at page 67.
Volume
2A, page 67.
Page
58,
58, but starts at 60. Actual submissions start at 67. Lord, the first submission that I'm making is with respect to the scope of reference, and I will, for that submissions are made, I will not, my lord, repeat that. My lord, on facts and the law of 1920, interpretation of that act to those facts, there is a decision rendered by a 5 judges bench. And that is, my lord, something which is concluded. In reference, my lord, on principle, everything can be relooked at. But those principles will be prospectively applicable, not with respect to the decision which is made, my lord, in that judgment. My lord, there is a judgment, my lord, of your lordship's court, my lord, 3 judges. I will just, my lord, read. It is, my lord, that judgment is, my lord, brought on record before your lordships in volume 5I. It's a special only, that judgment only. My lord, the citation is 2014, volume 5, page 800. And, my lord, of that, the observations only in para 12. I will read, my lord, those 5-6 lines. Reference of a case to a larger bench necessarily has to be for a reconsideration of the principle of law on which the case has been decided and not the merits of the decision. The decision rendered by any bench is final inter partes, subject to the power of review and the curative power. Any other view would have the effect of conferring some kind of an appellate power in a larger bench of this court, which cannot be countenanced. So, my lord, this is what I am relying upon for the first proposition. My lord, the second submission that I want to make, my lord, is with respect to the, my lord, in my written submissions, I have used the term dangers. My lord, your lordship may read it as the pitfalls. Dangers in accepting the independent status of the AMU as a minority institution. My lord, 69, my lord, page 69, that, my lord, caption is there. Dangers in accepting the independent status of the AMU. Dangers in the sense, not, my lord, political sense or, my lord, social sense. Purely legal sense, my lord, that's, my lord, my submission. My lord, the first thing, my lord, for that, my lord, for appreciating this submission, your lordships will have to, my lord, will have to bear in mind that entry 63 in list 1 takes care of the AMU as an institution of national importance. If AMU, my lord, is conferred or recognized to be a minority institution, my lord, the parliament will be robbed of the powers, my lord, conferred under entry 63. My lord, the wide nature of power that the parliament possesses, my lord, under entry 63 will be, my lord, curtailed if, my lord, it is recognized as a minority institution.
other than 2 institutions.
I'm sorry, my lord.
Other than 2 institutions.
Yes, ma'am. That will be undermining the authority of the parliament. My lord, conferring or recognizing a status of a minority institution will virtually taking away the powers of the parliament under entry 63, or, my lord, diluting those powers. And while interpreting 1920 Act or any act of the parliament, my lord, the court should avoid the interpretation which will result into undermining the authority of the parliament under entry 63 or any other entry. So, my lord, this is first danger that, my lord, needs to be seen in recognizing the minority status with respect to the AMU. Second, my lord, since my lord, Parliament attempted to do that by way of 1972 amendment and 1981 amendment, my lord, that also cannot be allowed to be done by the Parliament, because Parliament virtually will be abdicating its responsibility under entry 63. Entry 63 gives a wide power, and the moment the Parliament tries to, my lord, give that status to one of those institutions, my lord, as a minority institution, Parliament virtually will be accepting certain restrictions on the legislative powers under entry 63. That will amount to abdicating, my lord, the responsibility which is conferred upon the Parliament under entry 63. And my lord, that's why, my lord, your lordship put a question to the learned solicitor, can you argue this? I don't know, my lord, I need not answer that. But my lord, Union of India cannot do something which will result into abdication of or undermining the authority of the Parliament. This is second submission. My lord, if AMU is a creature by a special statute, it is, my lord, and my lord, funded almost entirely by the government. It is a state under Article 12. My lord, if it is a state under Article 12, then, my lord, it can't do something which a minority institution will be entitled to do. My lord, my learned friend Mr. Guru Krishna Kumar, my lord, pointed out in the last submission that scheduled castes, scheduled tribes, reservation, etc., will not be applicable to minority institution. That's, my lord, what the Act provides for. Virtually, my lord, though it is a state, and, my lord, bound by, my lord, mandate of Articles 15, 16, it will not be, my lord, liable to do that only because it is recognized as, it's a conflict which will arise as a result of that. So, my lord, this is my third submission with respect to the dangers of, my lord, recognizing or conferring a status of a minority institution on AMU. But there is one aspect which is covered. I will just put that the caption, and that caption that, my lord, there is a fundamental difference in created under the law and created by a special law. I have, my lord, analyzed that in my reason. I will not repeat that. Lord, one word of their choice was something that was, my lord, argued on both sides. In fact, Mr. Sibbal tried to give it a new dimension, saying that even if the minority institution or minority community goes to the government and requests them to create a law for it, for creation of that institution, that also will be of their choice. But my submission on this of their choice still adds a new dimension to it. Today, what way, my lord, AMU is actually functioning? Parliament has provided for everything. What Executive Council, Academic Council, statutes, how to be framed, what will be governed by the statute. Statutes governs, my lord, and ordinances governs even the control of examinations, even the awarding of degrees, appointment of professors, etc. It is, my lord, the choice of the Parliament. It is not any community, some different entity which is taking a decision. How do I administer it? But it is the wisdom, discretion, and the decision of the Parliament which controls everything. So, my lord, of their choice, in this case, it's only the choice. Therefore, I said discretion, wisdom, and the decision of the Parliament, which actually, my lord, is the manner in which the institution is run. So, my lord, this is of their choice, my lord, therefore, will not be available in case of an institution like AMU, which is a creature under the statute. My lord, this aspect also is covered. I will just paraphrasing it, and I will just, my lord, not repeat that. That, my lord, the institution is, the earlier institutions, MAO, etc., are dissolved, and new institution is entities. My lord, I am putting it, the Act of 1920 achieved twin purposes. And, my lord, I am putting it, paraphrasing it, once for all. Once for all in the sense that has happened. There is something inalterable thereafter. One is dissolution of the old institutions and establishment of the new entity. That has happened once for all. And therefore, my lord, 1981 amendment cannot, my lord, seek to alter something which has already occurred, and those provisions are
down now. Thank you, Mr. Navre.
Look, there is only one thing, last submission. Lord, your lordships have seen entry 63. BHU and AMU are both, my lord, on par in entry 63. The moment, my lord, this is again part of that pitfalls, the moment you recognize it as a minority institution, my lord, even-handedness of the parliament's power with respect to two institutions again will be affected. What parliament can do with respect to BHU will not be able to do with AMU. So, my lord, entry 63 virtually will be rewritten as a result of that. And therefore, my lord, this, my lord, the submission made on behalf of the respondents, the other side, my lord, may not be worth accepting. I am obliged to that.
Thank you.
There is last submission, but my lord, since my learned colleague reminds me, my lord, the minority status of institution under Article 30, your lordships have held that it's state specific. Lord, if AMU is established by the parliament, treated as minority institution, what do we do with respect to its campus, my lord, on the Jammu and Kashmir? Lord, that's the question which may arise. And therefore, my lord, that also is the conflict which may arise.
Too short.
Yes, Mr. Banerjee.
I don't want to repeat. I know I'm possibly right at the tail end, so and I'm sure.
Yes, Mr.
There are-
Banerjee, what is it?
Just two short issues, Malaz. One, I've submitted my note, which is volume 2K, Malaz. That's what I've been informed at the last moment. Just two short points. One is in relation to the three entries. Malaz, I'm not going to, I've elaborated that in my note, but I'm just placing this. That it requires to be interpreted. There are institutions of national importance in all the three entries. So no-cited sources has to be used to interpret all three. And Malaz, in relation to the first half, and Malaz, what has not been cited is, Malaz, I have quoted some of the extracts, Malaz, of Baba Saheb Ambedkar as well as Sardar Patel saying that minority protection, what is the intention of 29 and 30? And Malaz, I've quoted Bal Patil, which does not seem to have been cited, Malaz.
The Jain institutions claim under.
Not only that, Malaz, Jain institutions, but what Bal Patil actually does is addresses the question of minority. Malaz, only at the end, Malaz, will recall, if my lords have gone through Bal Patil, Bal Patil deals with the history of how minorities are formed. And it mentions in paragraph 33 specifically that the intention of the protection of 29 and 30 is a temporary way to ensure that the minorities finally disappear into the majority. So it's not to have a construction which will perpetuate minorities. Now, what we are doing in the present case is if we say that the state can create such minority institutions and so on and so forth, it would effectively go against the intention and objective of the interpretation of, and Bal Patil, my lords will recall, it's a 3-judge bench, and my lords, I can project it, or para 33 if lordships are willing to bear with me and read the paragraph 33. My lords. It deals in great detail as to the history of, if lordship allows me to place that, my lords, I think Bal Patil would be relevant, my lords. My lords,
All right,
para 11.
We'll have a look at it.
Malaj, I only say this, para 11 and para 33.
11 and 33.
Obligements. Malaj, that's part of my note which I have enclosed.
Thank you, Mr. Banerjee.
Obliged.
Yes, Mr. Potteraju.
Lordships, my submission is on first principles. The original provisions of the Constitution had Article 12, 14, 15, 28, 29, 2, as well as entry 63 as one scheme. There's a new sovereign, the people of India, who gave them this Constitution. They chose to elevate certain institutions which were established by an enactment prior to the Constitution coming into force and have conferred certain rights on the citizen of this country to have access to education in institutions under 29(2). The institution in question, the Aligarh Muslim University, was a 29(2) institution in which all the seats were available to the citizen of India until 2005. So for the first time, the citizen of India have been deprived only on the basis of their religion, access to admission, consideration for admission on merits in the case of PG medical seats in 2005. The judgment in 1967 has upheld the constitutional status as a secular institution. Now, lordships are sitting in a combination of 7 judges deciding a question of seminal importance. The interpretation lordships will choose would have to be in sync with the constitutional spirit, which is upholding the doctrine of secularism, which we have actually enshrined as a basic feature of our constitution. Now, what is the interpretation which is sought to be given today? The interpretation which is sought to be given today is the original scheme of the constitution, which has conferred certain fundamental rights on an institution which is classified. My submissions in volume 2M have stated, my lords, AMU qualifies as a state under Article 12 on the day the constitution comes into force, because it is maintained by the state. I've referred to section 35 in the 1920 Act and the substituted section which came in the 1981 amendment. Both of them mandate that the accounts and audit will have to be done and be published pre-independence, post-independence in the Gazette of India. In the pre-independence, in addition to Gazette of India, in the local gazette. Further, 35(4) post 1981 mandates the audit by the Comptroller and Auditor General. The finances which are going into the institution have been demonstrated, my lords. The scheme of the constitution has created certain rights in favor of the citizen of this land. Now, those rights are now being diverted or being actually taken away by a parliamentary legislation which does not seek to even refer to the judgment of the Constitution bench, much less refer to entry 63 status. With great respect, my lords, entry 63 is a status conferred on an institution, not merely a origin or a establishment of a new institution. The historical background has been set out, my lords, by Mr. Ragesh Dwivedi, Learned Senior Counsel. The background of 1916, 1920 is where we moved to a secular constitution in 1950. The new sovereign was conscious of the pitfalls of the two-nation theory and have expressly rejected it. And by rejecting it, they elevated both universities, though named as the Banaras Hindu University and the Aligarh Muslim University, as institutions of national importance. Once they elevate it, some purport has to be given to that status being conferred under the original constitution, my lords. The third point that I would like to make, my lords, is that an institution of this significance, once it is an Article 12 state, it ceases to be an Article 31 minority institution on the commencement of the constitution, because there cannot be a situation where it could have been an instrumentality of state or otherwise, but this is an institution which existed on the day when the constitution has come into force. So therefore it becomes a state on the date when the constitution comes, and it becomes Article 12. So 31 is not available to this institution, my lords. And AMU, as a creation of the statute, through its registrar, who is also a creation of the statute, cannot actually question the constitutional status of the university, which itself is a part of the original constitution. The stream cannot question the source, is my respectful submission.
Thank you, Mr.
I'm grateful.
Yes, Ms. Sachna Dave.
Wait, please, Manoj. Well, it's taking the point further. I don't want to repeat myself because already much has been said on this side. But Manods were particularly asking about the legislative debates. And I could find one paragraph which I would just read. That's in volume 4H and page 14. I can just read it, my lord.
Just a second.
Sorry. Let's where
Volume 4H.
4H, page 14. They are talking about the national character.
Just 1 second.
Yes.
At page
14,
14.
first column, down left.
This is the 81 amendment.
Yes.
Sorry, 60. Yeah, because this is
No,
Chagla.
Malus,
Mr.
61,
Chagla was there.
additional compilation of legislative debates, page 14. Malus, have that?
First column, second column.
First column, down right, left,
It starts like this.
MC Chagla.
Aligarh University is a national institution, an institution
MC
of
Chagla, right?
Yes. The last paragraph, left column, Aligarh, my lords, have it?
Yes.
Aligarh University is a national institution, an institution of national importance established by the legislature and continued by this parliament. Parliament has got every right to deal with the administration of the university either through an ordinance or by changing the law. It would be a most extraordinary proposition to suggest that this parliament, this sovereign legislature, has no right to interfere with the administration of the Aligarh University, which is Mr. Anthony's argument. It was never accepted by the British government, although there was no constitution. And even in those days, if you look at the dispatches, I have gone through the history of this when the Governor General sent the dispatch to the Secretary of State suggesting the starting of the Aligarh University. It was made incumbent that the doors of the university shall be open to persons of all castes and communities. Even that, British government would not permit a university to be set up to be financed by Indian money, which would be communal in its character. But as I said, they did not make this concession about this court, which we could not keep up because of our constitution. So, my lords, taking this further, this is with regard to the national importance, the national institution. Also, my lords, if I can say, the judgment in Aziz Basha is for a standalone institution. If I can say, this is a judgment in personam. What it is deciding is the character of the university, AMU University, as a standalone university. Both BHU and AMU are on a similar footing.
I also want to read page 12, Archana.
Yes, my lords.
Column 2.
Yes, my lords.
That is again Mr. Chagla's speech.
Yes.
Just read from the right that is conferred.
The right that is conferred upon minorities, it is important to note, is to establish and administer educational institutions of their choice. My submission to this House is that Aligarh University has neither been established nor is it being administered by the Muslim community. It is not a minority institution in the sense in which Mr. Anthony suggests. I will give him the reasons. You had first the Muslim College, which was founded by Sir Syed Ahmad. Sir Syed Ahmad asked the British government of those days to establish a university, and the British government in 1920 passed the Act of 1920. The legislature of those days passed that act and established the university. Therefore, the establishment of the institution was by legislature and not by the community. Whatever might have been the origin of the Aligarh University itself was established by the legislature. Then came the Constitution. Then in 1951, the Amending Act made certain alterations. In our own Constitution, in the Union List entry 63, it is provided that central universities and other institutions of national importance can be legislated upon the Parliament. Now, I cannot understand how it can be said that the administration is in the hands of the minorities. The administration of the university depends upon the law. During British times, it depended upon this act. After independence, it depends upon the act as had been amended by Parliament. Does Mr. Anthony suggest that it is open to the Aligarh Muslim University or the Muslim community to change the administration of the university even to the slightest degree and go contrary to what Parliament has laid down? If the minority had the right to administer the Aligarh University, then it can have any administration it liked. It can change the administration and it can close down the university. It can change the constitution of the court or the executive council. Can it do so? Even the constitution of the court, of the executive council, and of the academic council is regulated not by the minority committee, but by the Parliament. There is another aspect of the matter which Mr. Anthony has completely forgotten. He has attached great importance to the fact that under the Act of 1920, the British government, as a concession, said that the court shall consist wholly of Muslims. Now, everybody knows that the university is administered by the Executive Council and not by the court. The court, of course, is the supreme authority, and it is like a showpiece. It meets once a year. Lots of people come there and make speeches and pass resolutions. But the day-to-day administration, selection, appointments, and so on are carried on by the Executive Council. And it is significant that even in the British days, it was not provided that the Executive Council shall consist only of Muslims. That clearly shows that the British government did not concede the argument. Although there was no constitution, then the argument is now advanced by Mr. Anthony that the minority has a right to administer this particular institution. I say that this institution was not established by the minority, nor it is being administered or was ever administered by the minority community. That is the legal position as far as Article 30 is concerned.
What else, Miss, anything, what else do you want
Yes.
to?
Well, so my humble submission is, Malad, Aziz Basha, who is holding the field till today, is a good law, and it is only deciding the character of one particular university, which is AMU in this case. Well, it's the Parliament by the 1981 Amendment Act brazenly tried to overrule Basha's judgment, which it could not have done, my lords. I'm so deeply obliged
Thanks, Ms.
for
Dave. Thank you.
patient hearing.
Can I get just 2 minutes each? I'm appearing for the National Commission for Scheduled Castes. Because Mr. Yogeshwar had filed the written submissions. However, my lords, there's a bereavement in his family, so I just need 2 minutes, my lords. The first submission is that the appellants have based their submissions on the extent and width of Article 31. On an interpretation of Article 31 and interpretation of TMA Pi in Inamdar, it has been held that it's only an added protective measures and it is triangular. At the top, the rights of the minority to establish institution is narrowed down and virtually zero. Hence, you cannot enter into the protection of minority institution directly as a university. Even deemed university, they first become institution of eminence. Then there is a procedure to get themselves declared. That's the first point. Second point was following this in TMA Pi and interpreting that in Inamdar, it has been held that Article 31 is now subject to Article 29(2). Once the field on any seat of any institution is occupied by 29(2), and because it is a superior right, it cannot be relegated back to an Article 31 seat. Just 60 seconds more. The next point is that minority rights to establish and administer institution cannot extend to a minority university at the start. Fourth point is, Lords, the case of St. Stephen's. If we look at the factual ambit, St. Stephen's clearly said that it was established to spread the gospel, and the same charter of spreading the gospel was also registered with Delhi University. And a ritualistic religious head, that is the bishop, occupies the position as the chairman and nominates bodies. Milord.
Mr. Yatendra Singh.
Sir, volume 2C.
Give Mr. Yatendra Singh.
Your Lordships granted me 5 minutes. Probably I cannot finish in 5 minutes.
Tell us what the point is. Of course, we'll hear.
Yeah. Please inform me when the 4 minutes are over. 1 minute time, I want to tell your Lordships something which probably even they don't know about their own university. And there's a one particular case.
Why didn't we begin with that then?
My lords, I'm sorry. Lord, I have 5 submissions to make.
Yes, Mr. Yatendra.
And Lord, I will argue the traditional way. Lord, I will feel more comfortable. Just pass on. This doesn't contain any of the annexures, only my written submissions. There are 7 submissions. Submission number 1 is, number 1 is plain language should be given natural meaning and should be read as and not or. Second submission is,
Where is that, Mr. Yatendra?
your Lordships may have my this submission, and there's a
Page? What page?
written submissions, page 2.
Page 2, all right.
My lords. Second is, university AMU was established by, it was not established by Muslims. The third one is that it was never being administered by minority Muslims. And the fourth one is, without changing the basis of Basha case, the legislature cannot reverse it. First and 4 are settled point. Second and third are very well dealt by Solicitor General. I have mentioned them in Annexure A. Of course, Lord, I have given entirely a different color than what the Solicitor General has given. Your Lordship's pleasure is, if you want to read it, your Lordship may read it or omit it. Now, Lord, I come to the 5th point. What is the meaning of the word minority? Mr. Dwivedi has elaborated a lot. I must confess, it is a very novel way he put it. And your Lordship will deal with it, the treatment that it deserves. But actually, To my mind, minority in Article 30 does not mean numerical minority, which is the general trend of this court. It means electoral minority. A minority that cannot affect any elections. Like take up the case of Zoroastrians.
But it will vary from constituency to constituency. There may be some constituencies where you can certainly affect the elections.
Beloved,
Others
Your Lordship,
not. So do you look at it at the whole statewide level, the
Your
national
Lordship, just permit me to just complete this point and ask. Otherwise, I just want to finish within 5 minutes.
Yes,
I want to finish it.
yes.
We will continue after lunch.
Lord, democracy is a basic structure of the Constitution. Lord Acton, in his Essays on Freedom, says, most certain test by which we judge whether the country is really free is amount of security enjoyed by minorities. That's Lord Acton in his Essays on Freedom. It's mentioned here in paragraph number 2, Millards. This is the reason why rights to minorities were given under the Constitution. Now, if this is the case, then any minority which affects the election results is not a minority under Article 30, but like take up a case of Zoroastrians, that is Parsis and Iranis. Those who came 800 years ago, Milord, Persia was there, they are known as Parsis. Those who came 200 years ago, Iran was formed, they are known as Iranis. Now, they are about less than 1%. Bauths are less than 1%. Sikhs are less than 1%. They can't affect, Christians are 2.4. They can't affect any elections. Muslims in 211 census were 14.2%. But their population is the highest. My Muslim friends, when I talk to them, how much do you form the population? They say, now we have become 23%. So Muslims as a minority affect the elections. And that is the lot, if Bhindawale was creation of Mrs. Gandhi, then Owaisi is a creation of BJP. They want to divide the Muslim vote. Wherever they combine together, they win. You will have your chance. You will have your chance. But that's the way I thought.
We not steer away from the area of constitutional law.
But not your lordship's way. You're rejected. Your lordship may reject it. I'm again saying that. But I'm trying to say is.
Let's not comment on
all right.
Political personality.
Your lordship may not comment it. Your lordship may hear the next sentence which I am going to say. Because I just mentioned it as a reference. Your lordship, this court is not competent to decide this question, whether they affect any elections or not. That is why, my lord, I mentioned that your lordships may have some kind of commission may go into this question. That's all.
So according to you, Muslims are in a position to affect electoral outcomes, and therefore they are not a minority, according to you.
That's right. And for that, your lordships cannot go into this. No court can go into this question. A commission may be formed. For that, I was laying down the basis, my lord. I also know, I understand much better than Mr. Sibbal what are the limitations of the court. As a judge also, as a lawyer also. This is all that I have to say on this point. My lord, the Chief Justice has asked a particular question to Mr. Kaul. He gave a particular answer. I have given a different shade to it. If your lordship may have page 4. Paragraph 4. I'll just read it. The 6th and the 7th one, I'll read first the submission, and then I'll read my answer. 6 is the Principal Act, that's the original act, as amended from time to time, was further amended in 1981, the 1981 amendment. By this amendment, the 4 major changes were claimed. The most important change is Section 2L. Definition of the university. Then your lordship may come to the 7A. Assuming though not admitting that basis of Basha case was changed, thus rendering it, the Basha case, as no longer a good law, then these amendments are illegal on the following ground. Number one, they are arbitrary and illegal. B, they go against the secularism and equality basic feature of the Constitution. Point number 6 and 7 are dealt in page number 4.
Thank you so much. Now,
No,
all
I'll just take 2 minutes more. Just let me complete.
Yes, certainly. Yeah, tell us, we will hear it for a minute.
Sure. I'd like to read this particular point.
Sure, we can read it. Which point, Mr.
Page 5. Page 4.
Page 4.
Look, I'll take 5 minutes more in case your lordship can give me just 5 minutes more after the. All right.
Seeking 5 minutes, then we'll take on reading it. Yes.
6 and 7.
Yes.
In Basha case, it was held that AMU was established by the Principal Act. Kindly see the second submission on Annexure A. This finding cannot be reversed unless the basis is changed. This can only happen if the status quo ante or the way the things were before the Principal Act came into existence happened. In other words, the Principal Act is repealed and administration as well as properties are reverted back to MAO. Declaration in section 2L, broadly providing the university to mean educational institution of their choice established by Muslim, is not inserted with retrospective effect and is pure fiction. As in Haddock and Haddock, that's a dissenting opinion of Justice Holmes, which later on became the majority opinion. Fiction always is a poor ground for changing substantial rights. It's a dissenting opinion, but some words of wisdom. Then you'll also come to next page. There is no change in the basis for decision in the Basha case. The legislature cannot reverse it. Section 2L providing artificial definition to the word university is arbitrary. An arbitrary statute provision violates Article 14 and 16. I mentioned number of acts, but Lok Prairie case is the best case for all. And secularism and equality are the basic feature of the Constitution. I have cited Justice P.B. Gajen Garkar. Probably this book is not there with your Lordship library. I have the book in case your Lordship wants it, though I have annexed the relevant pages there. Then there is Austin Granville quotation. I don't want DC. There's a very good book by Justice Cheddappa Reddy, where he talks about secularism was not part of the Constitution. Was nowhere mentioned in the original Constitution, but how it was part of the Constitution. That's what he said. And the crux of all this is Indian secularism respects all religions. It does not favor any particular religion. Once you establish the institution for a particular religion, it violates the basic principles of equality, secularism, Article 15. Now, look, this is one particular case was not mentioned precedent. Let me explain this and then I'll finish. It was yesterday my young team suggested to me to put it there. You also must have read Spider-Man comics in your childhood. Spider-Man has a kind of a toy. From here, he can throw this web. Now, this was subject matter of patent dispute. It went up to Supreme Court. The Supreme Court was, US Supreme Court was asked to reverse a decision which they have already taken. What they ended up saving, the advice of Uncle Ben to Peter Parker. With great power comes great responsibility. Will it be your Lordship's pleasure? And they did not overrule it. That case was 51 years old. Here it is 55 years old. Kindly read what the US Supreme Court.
But they overruled Roe versus Wade.
Your Lordship will read it here. I will read, which is in my favor. Dr. Rajiv Dhawan is a very competent lawyer. He probably I personally rate him as somebody who knows the law, there's no other person who knows as much law as Dr. Rajiv Dhawan. I have a great fascination. I grew up doing a hero worship for Rajiv Dhawan. He used to live very across the road. Hero worship for him.
I'm embarrassed.
No, Rajiv, you are undoubtedly one of the greatest advocates India has seen.
Thank you.
Your Lordship,
We'll have a look at it.
Huh?
We'll have a look at it. Thank you.
Can I read that particular line?
No, we've seen that judgment, yes.
And just one more. Look, one more incident I'll try to tell your Lordship. That will bear in mind. That not 30 seconds I'll take. But Andre Vail was the greatest mathematician of last century. He was impressed by Gita. And during World War, when all the scientists were running away, he was a Jew. He came back to India. Schrodinger was supposed to come to India. He got appointment at Allahabad University, and he got, unfortunately, a professorship in Aligarh Muslim University. Now, he was impressed by Gita. India was a land of promise. He wanted it to be, he always used to quote Gita, he used to take turn. There's a principle of equivalence. He says, there's a new avatar. Like Vishnu had 10 avatars, that's how he used to do. And unfortunately, he was trapped in AMU. Now, AMU had an atmosphere which was, say, let's say, put it, anti-Hinduism kind of a thing. And they tried their level best that you actually hear me. There's some relevance. There's some relevance, otherwise I wouldn't have insisted. He went back. He left AMU, embarrassed. Had he been here, India would have been, AMU would have been Princeton. AMU would have been Stanford. And India would be producing one of the finest mathematicians, and we lost that. I'm obliged. Oh, yeah.
Now, anything else that has not been said, we'll give you
Yes, I have.
30 seconds. Yes.
Sir, 30 seconds, I will complete. Sir, volume 2C, page number 2, and I will highlight only 2 points of my written submission. And
What is the points? Just say, tell us already.
to consider the minority status of the Aligarh Muslim University under Article 30 of the Constitution, we have to examine, can an educational institution created by the Parliamentary Institute enjoy minority status under Article 30 of the...
Mr. Sharma, this has been argued, repeated.
Sir, let me, I am completing the chair, sir. Sir, please 1 minute. If the answer is yes.
50 बार यही हुआ है, इसमें बहस इसी point पे आप.
That side, so that's why. Please 1
You are supporting that side.
Sir, being an intervener, and as a respondent, any respondent can support.
You are supporting the petition. You are supporting the petition.
Yeah, sir.
I don't think they require your support right now. You argue.
Please 1 minute. Sir, I am only requesting you.
Yes.
Sir. Then there can be 2 ways. If an educational institution has been established for minorities under the Act, it should be declared a parameter for granting it minority status under Article 30 of the Constitution. If the spirit of creating educational institution by the Parliamentary Institute is for minority, it can also enjoy minority status under Article 30 of the Constitution.
Okay.
Now, the Aligarh Muslim University is the well-established fact is created by the AMU Act 1920 and passed by the Imperial Legislature. Let me say, when they used the word Muslim in the AMU Act 1920. Secondly, Mr. Surendranath Banerjee was allowed to speak in that time in the debate as the representative of the Hindu community, and he praised and supported the bill. And also that time Governor General congratulated the Muslim community. Clearly the spirit of the act was in the favor of
Lordship, I am representing respondent number 10 and 11. Originally,
So that's why.
fought for the reservation when the reservation was sought to impose
Right.
by the ME. So, my lord, just I don't want to repeat anything, but I want to highlight one very crucial aspect. Kindly see, I discussed how the genesis of the AMU lies in the 1920 Act. If we started from the 1872, there were 2 groups, moderate called Wafadar Party and all. So, my lord, there were 2 prominent figures who were the part of the moderate groups. One was the Muhammad Safi, who tabled the bill. Page 43, volume 4C. It is specifically mentioned while tabled the bill, the Muhammad Safi said, the AMU, like the BHU, having the all India character. All India character means, your lordship, the national character. Second prominent figure was Dr. Maulana Azad, our great leader. He was present in the 1920, along with the Muhammad Safi, that group. Another group, of course, did not agree, and they started the Jamia. They passed the resolution Jamia in the Aligarh itself. He started classes there by occupying some of the classroom, and thereafter shifted to the Delhi, your lordship. Now the Maulana Azad, who was right in the 1920, also was in the Constituent Assembly, was the part of the Constituent Assembly.
There has been argued.
And he was also...
You're not here all the time. We have been here all the time.
And he was also in the 1951, at our first education, Mr. My lord, kindly see.
Thank you.
I love the legislative your lordship, kindly allow me just 5 minutes, nothing more.
It's concluded on this side now.
Just
upon you now.
Your lordship,